Court Rules Research for the Advanced Legal Research course at Boston College Law School. Court rules govern the litigation practice and procedures in the courts. The establishment and jurisdiction of most courts is governed by statute, but courts are usually authorized to adopt rules to further define their processes and procedures. Court rules exist on both the state and federal level. They set forth the procedures for initiating, defending, and appealing cases. The purpose of these procedural court rules is to promote uniformity and assist the court in conducting its business efficiently. Court rules that have been validly adopted have the same legal effect as statutes. Within a court system, there are a number of categories of rules. The first is rules of general application. These typically include the rules of civil procedure, criminal procedure, and appellate procedure, as well as the rules of evidence. Here in Massachusetts, we do not have formal rules of evidence, and the courts rely on common law for most evidentiary rulings. The next level is rules for specific courts. At the federal level, this includes the U.S. Supreme Court, the Bankruptcy Courts, U.S. Tax Court, the Foreign Intelligence Surveillance Court, and the U.S. Court of Federal Claims. State courts have courts of general jurisdiction as well as courts of special jurisdiction, which are empowered to hear only cases of certain kinds. Courts of special jurisdiction will have their own rules. Some examples of state courts of special jurisdiction are family court, housing court, drug treatment court, and probate court. In addition, many courts have local rules, which supplement the rules of general application and govern the specific court's own internal operations. Another supplemental procedural rule is the standing order. Standing orders can be issued by a court or an individual judge. Local rules and standing orders are subservient to the general and specialized rules and do not supersede the existing rules. There are many places to find the rules themselves. In many law firms or government law offices, especially in a litigation practice, individual attorneys are given a personal set of the federal and state court rules. Court rules can also be found on court websites. The United States Courts website has PDF versions of the Federal Rules of General Application, as well as the rules from many of the special courts. Local rules and standing orders for a court are often available on the individual court web page, like this page for the U.S. Bankruptcy Court for the District of Massachusetts. For the standing order of an individual judge, check that judge's web page. A disclaimer, the standing orders were much further down on this page, but I wanted you to see the top of the page and the links to the standing orders in one slide. State websites also contain rules of court and standing orders. Massachusetts warns us not all Massachusetts rules of court are available online, and what is here is only an unofficial version of its rules. Find court rules on Westlaw under Content Types, Statutes, and Court Rules. You can select content type first, after choosing a jurisdiction. Westlaw treats court rules as part of their annotated codes. Lexis also treats court rules as part of their annotated codes. Find federal rules on Lexis under Federal Content USCA Federal Rules Annotated. For individual states, the court rules can be found under Statutes and Legislation, selecting that from the Lexis homepage or from an individual state's page. Find court rules on Bloomberg Law in All Legal Content under the heading U.S. Courts. You can also access an individual court's rules on Bloomberg Law by typing the source name into the universal search bar and selecting that source or browse TOC. Having located a relevant rule, one of the places to look for interpretive materials is to look to the comments from the drafters of the rule. In the federal system, these are advisory committees of the Federal Judicial Conference. The advisory committees of the Federal Judicial Conference is made up of lawyers, law professors, and judges. They are responsible for drafting proposed rule changes, considering comments from interested parties, and writing the notes of the advisory committee, which, though not binding authority, do provide insight into the purpose and language of the rules. These notes appear with the rules on Lexis and Westlaw and in some print versions of the court rules. Procedural rules are frequently cited by courts, and case law applying those rules can be useful in court rules research. Because Lexis and Westlaw include federal court rules in their annotated codes, there are editorially selected notes of decisions on both platforms, as well as other editorial features available on those platforms. Cases that cite federal and state court rules can be found using the citators on the three major legal research platforms: Shepard's on Lexis, KeyCite on Westlaw, and BCite on Bloomberg Law. Shepardizing a rule on Lexis, you have the same ability to shepardize by subsection that you have in shepardizing a code section. These citators can also be used to validate the rule and any case law relied upon, an important step in any legal research. There are also a number of treatises on court rules that can assist in developing a better understanding of the often complex court rules. Among the most respected and most frequently cited are Moore's Federal Practice, available on Lexis, and Wright and Miller's Federal Practice and Procedure, available on Westlaw. An amendment to a federal rule generally takes about 3 years. A proposed rule change is usually considered by an advisory committee and published for comment as part of a document called a preliminary draft during the first year of the process. Considered by the Committee on Rules, Practice, and Procedure, the Standing Committee, and the Judicial Conference in the second year, and by the Supreme Court and Congress in the third year. The Supreme Court has until May 1st to transmit an amendment to Congress for consideration. Congress may enact legislation to reject, modify, or defer the amendment, but absent congressional action, the amendment becomes law on December 1st.